You are welcome to Business Law 1 class. We are looking at Section 3 of Unit 2, Formation, specifically Consideration and Capacity. By the end of this session, you should be able to explain consideration and capacity, explain the changes or inroads made to the doctrine of consideration by the Contract Act 1960 at 25, explain the types of consideration, and identify people who have capacity to enter into a contract. The doctrine of consideration has been defined in the case of Curie v. Meiser, and it was defined as follows. Consideration was defined as a variable consideration in the eyes of the law, maybe either of some rights, interests, profits, benefits accruing to one person, or forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other person. What it means is that consideration can take different forms. It can be a person that another person, it can be a benefit that another person is going to enjoy, and as it's a benefit another person is enjoy, it is moving from another person as responsibility or forbearance for the person who is giving out. So the consideration is not only money, it can take different formats. It can be exchange of promise, it can be a loss that you have suffered, it can be a responsibility that you have to perform. Remember, if you don't give consideration in any promise, this means that you are a volunteer. A volunteer cannot enforce a contract. We have types of consideration. You have executory consideration, executed consideration, and past consideration. With executory consideration, here we mean that the parties have agreed on the terms and conditions, and one of the parties, or either of the parties, especially the promisee, is yet to perform his side of the promise. With executed consideration, this is whereby the parties have agreed on the terms and conditions, and one party has already performed his side of the contract, especially the promisee. We also have past consideration. Here, the past consideration is the case situation whereby what constitutes consideration has already been given before the promise is made. So it's the rule that past consideration is a bad consideration, and the party cannot enforce a past consideration. However, past consideration is enforceable when the act was done in the course of business. 2. When the offeror specifically requested the offeree to perform that act. Example of past performance, when I said you have washed someone's car, and because of that task you performed, the person said, oh, because of what you have done, I will give you 500 Ghana cedis. This is a past consideration because you did the act before the person gave the promise. Now let's look at 5 major principles under consideration. Consideration must not be past. You look at the case of Eastwood v. Kenyon. Past consideration is just what I just explained to you. You perform the act before the promise is made. So the consideration should not be passed. Consideration must be sufficient but not adequate. Should be sufficient but not adequate. Adequate simply means that what you are giving in return of the promise is equivalent to what you have received. Sufficiency simply means that you should give something in return, not necessarily equivalent to the promise you are receiving. And look at the case of Chappell v. Nelson. Consideration must move from the promisee. So here is promisee, not the promise. Consideration must move from the promisee. Now, we used to have the position in the case of Trader versus Atkinson that consideration should necessarily move from the promisee. But Section 10 of Act 25 has abolished this rule that consideration can move from any other person so far as the person is giving in the name or giving on behalf of the promisee. So you can enter into a contract and your friend or any other person can provide the consideration on your behalf. Also, an existing public duty is a valid consideration. Look at the case of Casey v. Charmant. However, if you know that in those cases, the court can decline to enforce the contract on grounds of public policy. So in this case, the ambassador to Liberia was asked to help a company to procure some concession, after that which certain benefits will be given unto him. He did so, and after that the company failed to give those benefits to him. He brought action, and the court indicated that even though it was the ambassador's duty to ensure that people get concession, and it's a valid consideration. However, on grounds of public policy, the court didn't enforce the contract. Part payment of a debt and a promise to forego part payments of a debt and a promise to forego the balance. So this is what she said. And in the case of the penal case, it was said that part payment of a debt is not a satisfaction of the full debt. So, and that's you. If I owe you me and ask you, oh, you pay half of the amount and keep the rest, I will not take it again. That one, later if I see you have gotten money, I can come for the balance. But under the Contract Act, part payment of debt or promise to forego the balance, you'll be held liable. The court will stop you from taking that money back after you have made that promise. So that's the position of the Contract Act against the penal case, which is a common law position. Let's now discuss the doctrine of privity of contract. It's a common law doctrine and simply state that only parties to a contract can enforce the contract, or the contract will force on them. So it's a common law principle which provides that a contract cannot confer rights or impose obligation upon any person who is not a party to the contract. So as I was explaining, if you're not a party to the contract, you don't have any rights under the contract, and you don't have any obligation to perform under the contract. That is the common law doctrine of privity of contract. Only the parties to the contract may enforce that right. It simply means that the contract will only create right and obligation for the parties. So if you are not party, you are excluded. Therefore, third party cannot acquire or enjoy any liability, incur any liability under the principle of privity of contract. And look at the case of Trader versus Atkinson. That's where the principle was generated, the locus classicus. Notwithstanding this principle, certain modification was made in the English case of Biswick v. Biswick. It introduced or it modified the rule in Australia versus Atkinson, which stated the purity of contract principle. And Lord Denny indicated that where a contract is made for the benefit of a third party who has legitimate interest to enforce, it can be enforced by the third party in the name of the contracting party or jointly by him, or if he refuses to join, by adding him as a defendant. So what Lord Denny is saying in the case of Biswick versus Biswick is that, look, if your father, let's say your father so your father representing F enters into contract with KCC Company Limited. That he has paid for Range Rover, for the Range Rover to be given to you, so you are going to benefit from the you will be Y. You are going to benefit from the contract. So your father paid for the Range Rover, and this company is supposed to deliver it to you because you are going to benefit. The previous contract is saying that, look, the contract was between your father and CC Limited. So they are the only people who can enforce the contract. And if there's a breach, it is your father who can enforce the contract against CC Limited. But the case of Biswick with Biswick introduced an element that, look, the contract was made to your benefit. You have legitimate interest. Now, once the parties were aware that the contract has made to your benefit, if C failed to deliver the Range Rover to you, you can bring action against CC Company Limited. That's what the case of Biswick states. Under our Contract Act Section 5, it also creates, or it is in line with what Lord Denny stated in Biswick. It says that a provision in a contract made after the commencement of this act, which purports to confer a benefit on a person who is not a party to the contract, that's the third party, whether as a designated person or as a member of class of person, may, subject to this act, be enforced or relied upon by that person as though that person were a party to the contract. The Section 5 is also saying that, look, if the contract was made to confer a benefit to you, then it doesn't matter whether you were not party to the initial contract, you will still have the right to what? Enforce such contract. So Section 5 and Biswick is it gives a modification the original doctrine of purity of contract. Now let's discuss capacity. Under the Children's Act, a child was defined as someone below the age of 18. Under the Constitution, a child was defined as someone below the age of 18. It means that if you are, the Constitution says that if you are 18 years and above, you can vote. It means that the Constitution, by inference, considers someone below the age as a person who is incapable of voting, and therefore the person is a minor. Under common law, a child cannot sue or be sued to enforce a contract, subject to some exceptions. So and this was based on the principle of mutuality. If you cannot enforce the contract on an infant, or if you cannot enforce a contract on an infant, then you can't force a contract on an adult where the two parties have entered into that contract. But we have exceptions to this case. Now there are sometimes certain contracts that will bind the infants. Now, infant, as we indicate, so we are going by the argument that if you are below the age of 18, you are infant for the purpose of contract. However, some people also hold the view that, look, there is no contractual age in Ghana. No law has been passed to be the contractual age. Therefore, you go by the common law position of 21. Now, if you are infant, then you may enter into any of these contracts. You have contracts for necessary and other beneficial contracts which are valid, and you also have voidable contract. Voidable contract means that the contract is valid until the infant takes steps to set aside. Now let's look at contract of necessary and other contracts. We are saying that when an infant enters into a contract of necessary, contract that are beneficial to the infant, beneficial contract of service, like you enter into apprenticeship or education or training, those contracts are binding on the infant. Let's discuss them one by one. So we are saying that when it comes to contract of necessity, we mean basic necessities like food, clothing, medicine, and among others, and it should be within the lifestyle of the person. Now, necessary has been defined by the Sale of Goods Act, and it states that, and this is a test you use to determine whether or not the item is a necessary item. And the condition is that the goods in question should be suitable to the condition of the person to whom they have delivered the goods to, and to his actual requirements at the time of delivery. This needs to be considered very well. So the goods should be suitable to the person's condition. For instance, the goods that you bought, it should not be some goods that are beyond your normal income. Also, it can happen that at the time the infant, you are entering a contract with the infant needed the item, but at the time you were supplying, there was no need for the item. Then it can be considered as a necessary item. Now, in the case of Nash versus Iman, the plaintiff could not recover the cost of 11 fancy waistcoats he sued for the infant, that the defendant. Now, this case establishes the principle that, look, if you enter into a contract with an infant, you enter it at your own risk. Now, when it's happened that the contract you enter is a necessary item, or the subject matter is a necessary item, then you will pay a reasonable price, but not the infant will pay a reasonable price, but not the market price. Also, contracts in which an infant enters into learn or enter for education, apprenticeship, those contracts are enforceable against the infant or minor. However, such contract must be fair to be enforceable. It means that when those contracts, even though the person is entering for training, for education, or for apprenticeship, if the terms of the contract is too harsh, the court will not enforce the contract against the infant. So look at the case of Dewey v. White City Stadium, where there was an agreement to train an infant as a boxer. There was no money paid, but the contract was enforceable as it was considered that the contract was beneficial because of the training provided. So he entered into a contract for him to be trained as a boxer. And once he's trained as a boxer, he's going to earn income from it in the future. So that contract was enforceable against the infant. In those cases, the contract should be considered as a whole. So the court will not uphold the contract if it doesn't inure to the benefit of the minor. Look at the case of Di Francisco v. Barnum. In that case, a minor who was 14 years of age entered into a contract to be trained as a dancer. And the terms of the condition was too harsh. One of the conditions were were that within 7 years of after the appointment, the lady can't marry. She was not supposed to take any engagement from any other company or person, and the salary for the lady was also small. The court, after they have considered the terms of the contract, came to conclusion that the contract does not inure to the benefit of the infant or the minor, and therefore the contract will not bind the infant. The contract was therefore set aside. Also, look at the scenario whereby the infant has performed his side of the contract. In that case, the adult cannot say that he will not perform that contract. And look at the case of Lamte v. Bannerman. You also have voidable contract. This contract can be set aside by the minor as far as he is an infant or after he has attained the age of majority within a reasonable time. What is reasonable time is a question of fact. Examples of such contracts include real property contract. That's the contract in the case of leasehold. You enter a lease on behalf of the infant. Partnership transaction, contract involving shares and marriage settlement. When you give a child's hand in marriage, the child has the right to set that contract aside, or he can wait when she reaches age of after attaining 18 or the age of majority. He can take steps to set the contract aside. But if she enjoys, for let's say about 5 years and she gets 30 and she now says she doesn't want to, that one, it will not suffice. You also have issue of drunkard. In terms of drunkenness, the court consider that if you are in a state of drunkenness, you don't have the capacity, you lack the capacity to enter into a contract. So you look at the case of Garvey Gibson, where the court said that it was said that a contract made by a person so intoxicated. So the key word here is the person so intoxicated as not to know the consequence of his act is not binding on him if his condition is known to the other party. So if you are intoxicated and you enter into a contract, that contract you can set after you have regained your senses, you can set the contract aside if you can prove that you were intoxicated. 1. 2, you didn't know the consequence of your act, what you are doing, and the party at the other side knew that indeed you were intoxicated. So, if you look at the case of Matthew v. Baxter, it said that if the drunkard party upon coming to his senses ratify the contract, he will bound by it. What it means that even though you were intoxicated, you didn't know the consequence of the act, the other party knew that you were intoxicated. However, if you get your senses and you still ratify, you still say, even though when I did this was the situation, I still admit the contract, then the contract will bind the intoxicated person. Lunatics too, in the state of lunacy makes a contract voidable but not void. It means that it is valid until one takes steps to what? Set aside. That one too, you have to prove that you, at the time of the contract, you were suffering from some mental, so it is mental disorder, not mental disorder. And to that extent, you were incapable of understanding the nature of the contract. Another party knew that this was your state. So the contract is voidable and not void. Void means it doesn't exist. Voidable means it exists until someone takes steps to set it aside. We have issue on enemy alien. If one citizen of a state is, if two countries are at war, the contract between the citizens of the countries will voidable. It means that one may take step to set aside that contract. So in terms of what, citizens of the enemy state may be denied their capacity to transact business and enforce claim under contract. Look at the issue of Russia and Ukraine. Such, if there's a contract between any of the parties there, or citizens from those countries, parties will be denied of their capacity to enforce their rights. Corporate body, they have right to sue and be sued, especially when they enter into a commercial contract. However, their contract will be subjected to regulations that or statutes that establish those corporations. Government has unlimited power to enter into a contract. You should also know that in certain contracts, government is required to take approval from the parliament, that is subject to parliamentary approval based on Article 181 of the 1992 Constitution. You should understand that under the 1992 Constitution, Article 88, it is only the Attorney General that has been given the power to prosecute and defend any claim involving the states. Session summary. In this session, we have discussed consideration, the types of consideration, as well as the contract. It was made to the doctrine of consideration by the Contract Act, and we have discussed their capacity in terms of infant, lunatics, drunkard person, and it's indicated that they have limited capacity. Thank you and have a nice day.